My business partner drained $3 million from our company. I used the RICO Act to take his house, his boat, and his freedom. This is the story of how my best friend, the co-founder of my dream company, stole $3 million from our shared venture, believing our partnership was a shield. But I wasn't just his friend. I was the guy who wrote the code, and I knew how to follow the digital breadcrumbs. He thought he was protected by corporate insurance, but I decided to dismantle his life using the most devastating piece of federal law available, the Racketeer Influenced and Corrupt Organizations Act, or RICO. 10 years ago, my partner Alex and I founded Synapse, a software company that optimized supply chain logistics. I was the chief technology officer, the brains. Alex was the chief sales officer, the charisma. We had a verbal agreement formalized by a partnership operating agreement that we were 50-50 owners. We were inseparable. Our success wasn't just financial, it was personal. We became family. Over those 10 years, Synapse grew from my garage into a $50 million valuation. We took no outside capital. We were debt-free and profitable, splitting healthy dividends annually. Our agreement was simple. All major expenses over $10,000 required mutual written consent. We both had access to the main operational accounts, but the financial oversight was always handled by Alex, who insisted he was better with spreadsheets. That was my first mistake. The warning signs were subtle, painted in expensive luxury. Alex started living a lifestyle that outpaced even our high dividends. He leased a new Ferrari every year. He bought a mansion on the coast. He even bought a 50-foot yacht named the Synapse. I asked him about it once. He just smiled and said, "We're successful, OP. Don't worry about it. It's all within budget." The real alarm went off when our bank called me. We were due for a capital injection to purchase a new office building, and the bank noticed a significant unexplained dip in our cash reserves. They called me, the CTO, because Alex wasn't returning their calls. I told them it was a mistake. I opened our QuickBooks account for the first time in 6 months. The total cash reserve should have been around $4.5 million. The screen showed $1.2 million. A difference of $3.3 million had vanished in less than 2 years. I immediately hired a neutral third-party forensic accountant, Dr. Chen. I didn't tell Alex. I told Dr. Chen to follow every single penny for the past 3 years. 2 weeks later, Dr. Chen presented her findings. The $3.3 million was gone, moved via a sophisticated web of fake invoices, shell companies, and fraudulent expense reports. Here is what she found. Fake vendors. Alex had created 2 shell companies named A-Tech Consulting and Lex Solutions, registered in Delaware. He classified these companies as high-priority software consultants. Invoice forgery. Alex approved and paid $150,000 every quarter to each of these fake companies for strategic development. This went on for 7 consecutive quarters. Total stolen $2.1 million. Asset conversion. He classified his Ferrari lease and his yacht's maintenance fees as marketing expenses and client entertainment. Total stolen $700,000. Cash withdrawals. He simply wrote checks to petty cash and signed them himself, depositing the money directly into his personal bank account. Total stolen $500,000. The total amount stolen was precisely $3,300,000. I confronted Alex in our boardroom. He denied everything, then instantly shifted to aggression. "You let me do it, OP. You trusted me. And guess what? This is just a civil dispute. Sue me. You'll get half of what's left after the lawyers take their cut. And the company's D&O insurance will pay for my defense. You'll spend 5 years and get nothing." He was counting on me being tired, broke, and unwilling to destroy my own company to get revenge. He was counting on the legal system being slow and expensive. He was right about one thing. This wasn't just a simple breach of contract. It was systemic fraud and theft. But he was wrong about the defense. I wasn't going to sue him under simple contract law. I was going to use a law designed to take down organized crime syndicates. I was going to use RICO.
Alex was right about one thing. A standard civil lawsuit for breach of fiduciary duty would have been slow and ineffective. He was wrong about everything else. I didn't want the remnants of our company. I wanted every asset he had ever purchased, and I wanted him to understand the true cost of betraying a partner. For that, I needed the RICO Act. I hired the only lawyer in Chicago I knew who specialized in civil RICO claims, a fierce attorney named Helen. When I told her the story, the 2 shell companies, the 7 quarterly fake invoices, the systematic theft, she leaned back and smiled. "This isn't simple corporate theft, OP," Helen stated. "This is a textbook pattern of racketeering activity." The RICO Act, officially the Racketeer Influenced and Corrupt Organizations Act, was passed in 1970 to prosecute the mafia. But Section 1964 allows private citizens like me to file civil suits against individuals who engage in a pattern of illegal financial activity using a business entity. To prove a civil RICO violation, we only needed 3 things. An enterprise, Synapse, our company, was the legitimate enterprise being used for illegal means. A pattern, we needed at least 2 predicate acts, underlying crimes, committed within a 10-year period. Predicate acts. Our predicate acts were not assault or murder. They were mail fraud and wire fraud. Alex committed wire fraud every time he used our accounting software to transfer funds across state lines from Synapse's account to his Delaware shell companies. He committed mail fraud every time his shell companies emailed those fraudulent invoices to our accounting department. 7 quarters of invoices meant 14 separate predicate acts. That's not just a pattern, that's a sophisticated, ongoing criminal scheme. Our civil suit was filed not for simple damages, but for triple damages. This is the nuclear option of commercial law. Under RICO, any plaintiff who proves damages resulting from racketeering activity is entitled to recover 3 times the actual damages sustained. Alex had stolen $3.3 million. We weren't suing for $3.3 million. We were suing for $9.9 million, plus punitive damages, plus attorney's fees. This was the first seismic shock. The second shock came the next morning. Helen immediately filed a motion for a writ of attachment and preliminary injunction. Because we had presented irrefutable evidence of ongoing fraud and the creation of shell companies designed to hide assets, the judge immediately granted our request. Before Alex even received the lawsuit papers, the court-appointed receivership took control. Agents arrived at his mansion with a court order. They seized his bank accounts, placed a judicial lien on his coastal property, and, in the most satisfying moment, towed his 50-foot yacht, the Synapse. Alex was instantly paralyzed. All his liquid assets were frozen. The $50,000 yearly legal defense fund he was banking on from the D&O insurance was useless. Because D&O policies universally exclude coverage for criminal acts, which is exactly what wire fraud is. His lawyer, paid with frozen funds, quickly panicked. They realized they weren't dealing with a corporate breach anymore. They were defending a RICO charge, which carries the weight of a criminal investigation. But we weren't done. The forensic accountant, Dr. Chen, became our star witness. She dug deeper into Alex's tax filings. She found that Alex had claimed the $3.3 million in stolen funds as tax-free loans from Synapse, rather than declaring them as income or illegal dividends. This was his attempt to hide the income from the IRS, but it gave us the perfect weapon. Dr. Chen showed that because the transfers were clearly fraudulent, the IRS could interpret the $3.3 million as undisclosed income, triggering massive tax evasion penalties against Alex personally. Furthermore, by paying his fraudulent vendors, Alex had committed a second layer of fraud by claiming business expenses that were entirely fictitious. Helen called the U.S. Attorney's Office. She didn't ask them to join the civil suit. She gave them the forensic report. "This isn't a civil matter," Helen told the federal prosecutor. "This is $3.3 million in unreported income, tax evasion, and a clear pattern of mail and wire fraud. We believe he needs to be investigated criminally." Alex thought the company's insurance would protect him from a mere lawsuit. He never accounted for the triple damages, the asset seizure, and the fact that committing a civil RICO offense is the fastest way to invite the federal government to look at your tax returns and your freedom. The battlefield had shifted entirely from our boardroom to federal court, and Alex was about to realize that the Mafia Act doesn't care if you wear a suit or a fedora. The civil RICO suit, demanding $9.9 million in triple damages, plus the immediate seizure of all assets, instantly shattered Alex's defenses. He wasn't just broke, he was underwater and drowning in federal attention. His high-priced defense attorney realized the only way out was surrender. Alex's legal team approached us for a settlement, but we held all the cards. Helen's demand was non-negotiable. Full restitution of the $3.3 million stolen, payment of our attorney's fees, $450,000. Alex must sign a notarized statement admitting to the fraud, which could then be used against him in the looming criminal investigation. Alex tried to negotiate, but the pressure was too great. The bank was threatening to foreclose on his mansion because his accounts were frozen, and the IRS was breathing down his neck. He signed the confession. The civil case ended in a default judgment in our favor. Alex was personally ordered to pay the full $3.75 million, restitution plus fees. Since his money was gone, the court ordered the sale of his assets to satisfy the judgment. I stood on the dock as the court-appointed receiver prepared to sell the Synapse Yacht. It was a clear symbol of his greed, and watching it sail away under new ownership was the ultimate moment of financial justice. The proceeds from the sale of the yacht, the Ferrari, and the forced sale of his condo went directly into Synapse's operational accounts, restoring the capital he stole. But the story didn't end with a civil judgment. The moment Alex signed the affidavit confessing to mail and wire fraud, the predicate acts, the U.S. Attorney's Office had everything they needed. 2 weeks later, the final shoe dropped. The federal government formally indicted Alex under the RICO Act for engaging in a pattern of racketeering activity using an interstate enterprise. And separately, the IRS filed charges for tax evasion on the undisclosed $3.3 million income. Alex went from being a millionaire business owner to a federal defendant overnight. He faces up to 20 years in prison for the RICO charges and separate time for tax fraud. His last call to me was from his lawyer's office, pleading with me to talk to the prosecutor. I told him, "The prosecutor isn't interested in friendship, Alex. They're interested in the pattern. You built a machine for stealing, and now that machine is prosecuting you." Synapse, the company, survived. I used the recovered $3.75 million to stabilize our accounts, bought out Alex's 50% share for $1, which was fair given his liabilities, and restructured the company. I became the CEO, and more importantly, the sole owner. Synapse is now worth over $80 million, a value I never would have achieved if I hadn't learned how to fight fire with federal law. The experience taught me that most corporate fraud is committed by people who think they are smarter than the paper trail. They rely on their victims being too scared or too broke to fight properly. I wasn't. But the real lesson came later. After the news of the RICO suit spread, my inbox filled with messages from others who were victims of their own business partners, small business owners, franchise holders, and minority shareholders. They were all facing the same problem: systemic fraud without the resources to fight a long civil war. I'm now consulting part-time, using the RICO Act as my primary tool to recover assets for others. My current case involves a major fast food franchise owner who systematically inflated payroll costs across all his 15 locations and funneled the excess cash into a cryptocurrency investment scheme. It's a classic pattern of racketeering. This franchise owner thought that by spreading the fraud across 15 separate state locations, he was safe. But the federal wire fraud statute applies to every single bank transfer between those locations. The potential penalties are huge. My question to you is, if this franchise owner is guilty of draining millions from his partners, should the government only make him pay back the money, or should they seize his entire franchise empire to pay for the crime? Let me know your answer in the comments below.